The next matter to come before the court this morning is Mackenzy Cook et al. Versus EMH Regional Healthcare System et al. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve any time, if you let me know when you get started, I'm keeping the clock and can keep you apprised of the passage of time. The court's read the briefs and we're ready to proceed when you are. Can you come to this podium? Sure. Thank you.
Oh, big sign that says, do not use this podium. My apologies. I have lots of my That's all right. Good morning, Your Honors. My name is Pamela Pantages. Attorney Paul Flowers and I represent the Mackenzy family in this appeal. If it pleases the court, I'd like to reserve 5 minutes of my time for rebuttal. There are two issues before this court: whether the trial court erred in determining that Revised Code Section 2305.25 applies only to patient care issues, and the second issue is whether or not the specific issues relating to Dr. Boro and his ACOG resignation over 11 years ago has any relevance to this case. My understanding from the court is that you have reviewed the briefs already. I will just touch briefly on the facts. This is a medical negligence case on behalf of 5-year-old Mackenzy Cook and her parents. It is a birth injury case with allegations of negligence against the obstetrician and the hospital for mismanagement of Mackenzy's birth that resulted in a partial paralysis of her arm, which she still is dealing with today. Dr. Boro was identified by us as our obstetric expert. Dr. Boro is a board-certified obstetrician-gynecologist in Philadelphia, Pennsylvania. He has over 30 years of practice and has delivered thousands of babies over the course of his career. Also at issue in this case is ACOG. ACOG is the American College of Obstetricians and Gynecologists, not to be confused with ABOG, the American Board of Obstetrics and Gynecology, the Board Certification Society. ACOG is a voluntary professional society. This morning, before my argument this morning, I went on ACOG's website, which we referenced in our brief, and at the top of the page, ACOG says, Women's Healthcare Physicians. On the ACOG website this morning, there's a photograph of a pregnant woman with the new ACOG pregnancy book, updated 6th edition, Your Pregnancy and Childbirth. Also, public information about the HPV vaccine for adolescent boys and girls. ACOG is an excellent organization. It prides itself on educating its membership and in improving healthcare throughout the United States. ACOG has an internal peer review process that applies to members only. ACOG can examine the conduct, the care, and the professional activities of its membership. It has no authority or power over non-members.
Excuse me.
Yes, Your Honor.
Is it mandatory if ACOG wants to review some conduct, is it mandatory that the physician cooperate?
If the physician is a member of ACOG during that process, yes, as I understand it.
All right, thank you.
Dr. Boro resigned from ACOG in good standing in 2004. He's never been sanctioned, he's never been censured, he's never had any ACOG reprimand against his license. In previous cases, Dr. Boro has been asked why he resigned from ACOG membership. He routinely indicates in his deposition testimony that he disagreed with ACOG's evolving political involvement, lobbying, and philosophies. He has refused in the past to discuss with defense counsel anything more than that, other than that he resigned in good standing. In this case, after the experts were identified, both on behalf of plaintiff and defendant, plaintiffs moved preemptively by way of motion in limine to preclude any further discussion of Dr. Boro's ACOG resignation in either discovery deposition or at trial. There was a hearing, the issue was briefed, and then Judge Burge held a hearing on the issue, and then came to a ruling from the bench at the hearing. The crux of, so Judge Burge ruled that the defendants may discover whether a complaint was filed against Dr. Borrow with ACOG arising from his preparation of either an expert witness report or his testimony as an expert witness in a claim of professional liability, the nature of the complaint made, that is the specific criticism of Dr. Borrow, and the identification of the specific case out of which the complaint against Dr. Borrow arose. The crux of Judge Burge's decision was that Revised Code 2305.25, which was the basis of our motion in limine, that any internal review of any of the membership, including Dr. Borrow, who was a member before 2004, is entitled to peer review privilege. The basis of Judge Burge's ruling that these matters were discoverable was that RC 2305.25 is limited only to issues involving patient care.
Boy, it sounds like if you read the trial court order that there's an unspoken part here, that there's something very specific that was in the contemplation of the trial court and the parties in this argument on this motion that they would like to get to. But after reading the briefs and looking at the order, I can't determine. You're telling me that the crux of the decision is on that basis. But what is in ACOG if he acted as an expert witness on another matter in litigation or through, I'm confused, I guess, as to what it is we're specifically trying to avoid questions.
We're avoiding questions on any aspect of if in fact, first of all, there's no evidence that there was an ACOG investigation against him, first of all. Second of all, and we're moving to preclude any further inquiry of that because even the existence of an investigation or even the existence of peer review activity or a complaint to a peer review committee is, the information about that is protected under the Ohio statute. So that's the first issue. The second issue is assume all that is true and assume this court agrees with Judge Burge and all that comes in. The second question is how is that possibly relevant? If an ACOG member, hypothetically a defendant in another case, was disgruntled because Dr. Borrow acted as a plaintiff's expert witness in a case against him and went to ACOG about that is specific to that case. The essence of Judge Burge's ruling is that the defense has the right to that information, has the right to get all of the depositions, the trial transcript or whatever, and determine if there's any merit to that. And what we said to Judge Burge at the hearing was, number one, how would anybody do that without having a trial within a trial? And beyond that, what would a jury do with that? How would a jury know in one case all of the details and issues and implications of a completely different case?
Well, so indulge me for a second here. If I break down the first part of the trial court's order, whether a complaint was filed against Dr. Borrow with ACOG, is a complaint only filed if there is an allegation that he was negligent, or can a complaint be filed because I don't like that person as a member?
A complaint can be filed for any reason. And that's what is specific to this statute, and that's why we respectively submit that Judge Burge was wrong in his interpretation of the statute.
Because if they can discover whether a complaint was filed, it could be relative to patient care issues.
Or it may not be relevant.
I understand that, but
Patient care
the order says the defense may discover the following, whether a complaint was filed. So
On any issue, not specific to, correct.
Thank you.
And getting back to the statute, 2305.25 uses in its definitional section healthcare entity. It doesn't say healthcare provider. It doesn't say hospital. It doesn't say healthcare institution. If you look at the broad language of all of the definitions in 2305, it's a hugely encompassing statute. 2305 paragraph A, section 1 says healthcare entity means an entity, whether acting on its own behalf or in affiliation with other healthcare entities, that conducts as part of its regular business activities, it doesn't even say healthcare activities, that conducts as part of its regular business activities, professional credentialing or quality review activities involving the competence of, comma, professional conduct of, comma, or quality of care. Judge Burge limited the application of 2305.25 to patient care when the statute clearly does not say that. Under paragraph A, section 2, healthcare entity includes, and there's a long list of things, which at the end of other healthcare organizations. So it could be a government entity, a for-profit corporation, a non-profit corporation, limited liability company, that's an insurance company who doesn't provide patient care, or other healthcare organizations. Down under section E, peer review committee means.
And Counselor, you are just now reaching your 5 minutes with the button.
Thank you, Your Honor. I'd like to direct this court to some of the precedent that this court has dealt with on this issue in the past, and point out that there are some cases that this issue is raised that have nothing to do with patient care. The Boutsakeris versus Akron General Medical Center case, decided by this court May 14, 1997, dealt with a couple of physicians at Akron General Medical Center that had bad blood between the two of them. Some things were reported to the peer review committee within the hospital, and this court determined that the privilege of the statute applied in that circumstance. In Hammonds versus Ruff in 2004, followed by Abels versus Ruff in 2005, this court said the language of revised code 2305.25 must be given its plain meaning. The legislature has left no doubt regarding whether these documents are obtainable from appellant. They clearly are not. Then in Abels versus Ruff, this court again stood by Hammond and said, as this court recently stated in Hammond in paragraph 11, the language of RC 2305.252 must be given its plain meaning. Then in Huntsman versus Altman, 5th District case, also in 2005, the 5th District relied upon this court's ruling in Hammonds versus Ruff and wouldn't even determine, let's strike that lay back up a second. In Huntsman, the Altman Hospital concluded that the activity and the documents and the information that was provided to the peer review committee in that circumstance was privileged, but ordered that the hospital should produce a list of information that was discussed or provided to the peer review. The 5th District, relying upon Hammond, said whether it's actual documents or a list of documents, the activity of that committee is protected under the statute. I'd like to address some of the defense arguments that were made in their brief. The defense agrees with Judge Burge that 2305.25 and 2305.252 are limited to patient care. Clearly, that's not true. There are circumstances where the peer review privilege should apply, certainly to patient care, but also it encourages free exchange of information within a healthcare entity about any concern about a provider, whether that concern has to do with patient care or whether that concern has to do with chemical dependency, sexual harassment, sexual assault, interference with business, defamation. Any of those things fall within the protection of 2305.25 and 25.2. The defendants also, appellees also took a position in their briefs that before the peer review privilege can apply, there must be a demonstration that a committee convened before the protection is triggered. Clearly, that's not true. If this court looks at its opinions in the Hammonds case and in the Abels case, those decisions arose out of motions to compel that were filed within a month of the complaint being filed. Typically what happens in many of these cases, as it happened in the Abels versus Ruff case and the Hammonds versus Ruff case, the plaintiffs had set forth an allegation of negligent credentialing in their complaint. The only way that they can support their claim of negligent credentialing is to propound discovery requests, formal document requests for credentialing file and other peer review activity having to do with, in this case, both times it was a physician named Dr. Ruff. there are certain people that are involved in the peer review process that can trigger the peer review privilege, but also there are people outside of that scope, including patients, who would have no indication, have no information whether or not a peer review committee took place. And in the Abel's decision and the Hammond's decision, this court never addressed the issue, never even raised the issue that the plaintiff had to prove the convening of a peer review committee before entertaining whether or not those documents were available or privileged. One other point that I wanted to raise at the beginning.
You have about 15 seconds.
Thank you. The standard of review of this case is de novo and not the abuse of discretion. This court, Your Honors, the plaintiff's appellants respectfully request this court to apply the plain language of Revised Code 230525 and 2305.252, conclude that the documents and the information at issue is privileged and not relevant to these proceedings. Thank you.
Good morning, Your Honors. My name is Adam Davis, and I'm here on behalf of the defendant appellees, Dr. Corey Kovach and Erie Shore Women's Health Incorporated. And it is our position we would ask the court to affirm the trial court's ruling on a discovery order that relates to the discoverability of information pertaining to the resignation of the plaintiff's expert, Dr. Larry Boro. Ms. Pantages spoke a little bit about the underlying facts of the case. I think it's important for the bench to realize that Dr. Boro has testified dozens of times in the state of Ohio. When he testifies in Ohio, it's 100% of the time on behalf of the plaintiff. He is a seasoned medical expert who has testified to about 25 states in the union. And in 2004, as was indicated, he resigned from his membership from ACOG, which is one of the largest, if not the largest, professional organization for obstetricians and gynecologists in the United States.
Yes. Does the record show that he gave any reason for his resignation, or is it entirely silent on that?
It depends on which state court transcript you've looked at. In some of the cases in which Dr. Boro has testified, he does give sort of a bland explanation saying that it related to political issues, what those political issues specifically were, who was soliciting about them, what he did to correct it. There's no explanation ever given. And in other occasions, he would simply refuse to answer the question and assert some sort of peer review protection. I think the central issue that is being, or really sort of the linchpin of this entire argument, is the plain meaning of the peer review statute and whether a peer review committee was ever formed. In order to assert any sort of privilege, it is the burden rested with the plaintiff to submit some evidence that a peer review committee met such that a privilege can be asserted. Without that evidentiary foundation, there is no privilege to assert, and that's the crux that Dr. Boro keeps running into.
I guess I'm just trying to figure this out too, because like Judge Hunsel, I keep reading this, I'm not sure what anybody's talking about, but the thing is, if you ask somebody, why are they no longer a member of a professional organization, and they say, I had political differences with them, why does the inquiry not end there?
Because we should have the ability to cross-examine or verify the validity of that witness's statements.
Well, he told you that.
Well,
Did you ask him, have you ever been the subject of a peer review committee?
he has been asked that many times, and that's what he refuses to
And that's
answer.
what he refuses, I'm sorry, that's right, that's when he refuses the answer.
Yes, Your Honor.
So if he refuses to answer that, then what are your options?
Our options are to move through the discovery process. We can do a couple things. We can ask that the witness answer the question. And I know that in many cases, he's been instructed, and then a second deposition will reconvene. If he refuses at that point, one of the options is to move to exclude all of his testimony for refusing to abide by the court's order. And the King case in North Carolina is the case where Dr. Boro was called back by the court to answer that specific question. He still refused, and as a discovery sanction, the court excluded his testimony. And there's a recent case that I just learned about from the state of Iowa where the exact same thing happened. That's from January of this year. But the threshold question is, can an expert assert a privilege based on the peer review committee privilege if there is no evidence in the record that a peer review committee ever met or ever formed? The clear language of 2305.25 says that proceedings and records within the scope of a peer review committee of a healthcare entity shall be held in confidence. And so the analysis of whether ACOG constitutes a healthcare entity, or whether it arises out of patient care, or whether the privilege applies to an expert versus a care provider, this court doesn't even need to address that, and Judge Burge doesn't even need to address that, because there is still no evidence that a peer review committee would have met to even give rise to a privilege. This exact scenario happened 6 months ago in the 8th District in the Blueberger case, which we cited. That case was dismissed before the issue could ultimately be resolved, but there was a court order where similar arguments had been made, again involving Dr. Borrow, and the court said, at the very least, you need to provide some evidence in terms of the date of this peer review committee that you're saying was the basis of the privilege, who was involved, not even getting to the substance of the proceedings, but just some evidence in the record. And that was the plaintiff's burden, to show that a peer review committee actually met. If there's no evidence of a peer review committee, then there's no basis to assert any privilege whatsoever, and Dr. Borrow should be required to answer these questions. And I think Judge Burge's order, talking about whether a complaint was filed, the nature of the complaint, and the ID of the case, are basic threshold questions that need to be answered by Dr. Borrow to determine whether there's a valid privilege to assert or not.
And this came from a motion in limine.
It's captioned as the motion in limine, but I think if you, by reading the transcript and by reading the order, the judge's order is a discovery order.
I understand.
So
what Judge Burge ruled, but I'm just trying to figure out what we're actually dealing with and what was before the court.
I think it is captioned as a motion in limine, but in a practical sense, I think it's treated much more like a motion for a protective order to preclude that type of discovery at the time of Dr. Borrow's deposition. I think at this juncture, any of us could speculate as to the relevance of this, but until Dr. Borrow can actually answer the question, I think it's premature for plaintiff appellants to make the case or suggestion that Dr. Borrow's answer would be irrelevant. Obviously, if the nature of the complaint was because he's giving testimony that's not sound medicine, or that he's done something that has caused ACOG to ask him to resign, we really have no idea what the specific allegation is, but the determination of relevance is a separate consideration that the trial court can make after Dr. Borrow gives his answer at deposition. That happens all the time with these types of questions. Defendant physicians are asked all the time, have you been sued in other cases? They answer the question, and then a separate determination is made at the trial court whether the jury can ever ultimately hear that evidence. And that shouldn't be any different in the case of Dr. Borrow and his resignation from ACOG. One of the distinctions in the brief was, well, ACOG is a voluntary organization. So are hospital privileges. For every physician that decides they want to practice at a hospital, for a variety of reasons, they can be asked to resign. It's still discoverable. The admissibility is a separate question.
It just seems like the procedure is kind of messed up here too, because, ordinarily you do file a protective order, file motions to compel, if you don't have discovery disputes. And then the court, may do an in-camera inspection, to look at the documents to determine if it's a privilege. It just seems that this procedure is just not quite right.
Well, I think regardless of whether the court, from my perspective, regardless of whether the court wants to treat it as a motion for protective order or a motion to eliminate, at the end of the day, based on the record before the trial court, there's still no evidence at all that would give or substantiate a claim for the peer review privilege on behalf of Dr. Borrow. There had to have been some evidence showing the existence of a peer review committee before that privilege can be asserted. I think while there are decisions, and I as we laid out in our brief, they have the burden of showing that, and the burden is strictly construed against them.
So let's say they answered the question and said, I'm not going to answer that because it's part of the review committee. Then what do you do?
Then I think we would petition the court for a hearing on the issue and ask for a discovery order saying, Judge, we'd like an order to have Dr. Morrow answer why he resigned from ACOG, whether there was a peer review committee, and if not, if he can't say there was ever a peer review committee that met on this date with these individuals, then he should have to answer at a discovery deposition any question relating to that. There's no privilege to assert at that point. It's simply fact-finding about the background of an expert. I think we would be back here because I don't think Dr. Borrow, based on the dozens of depositions where he's done the same tactic, would say the same thing. And then if he's ordered to come back, I think the plaintiffs would be in a tough spot, like the plaintiffs were in North Carolina, where they had to withdraw him as an expert because he refused to answer it. I also think that in their brief, plaintiffs were very careful to use the language. They're not even taking the position that a peer review committee met. They use the word, it's possible that a peer review committee met. And that's telling because, again, they have the burden of this issue and there's nothing in the record to substantiate the privilege. I would also point out that the case law that's cited in the appellant's brief really all deal with cases where there was no dispute about the existence of a peer review committee meeting. In the Higbee case where ACOG says, we believe we're a healthcare entity, we believe that there is a privilege attached. There was no dispute in that case that a peer review committee met, evidence was taken, a hearing was held, and so that case, while it may be instructive, doesn't apply here because we still aren't even past that threshold determination about whether there's a committee.
Well, and I'm looking again at judgment entry. The court says defendants may discover the following: whether a complaint was filed against Dr. Borrow with ACOG, arising from blah, blah, blah. But I guess the first thing is whether a complaint was filed.
Yeah, yes, certainly. If a complaint was filed, presumably that would lead to a peer review committee grievance procedure.
Well, you're assuming things again, and that's what we're all doing here, it seems like.
Yes, but that actually weighs in favor of the defendant appellees because we would be able to discover whether there's a complaint that's filed. That doesn't arise out of the peer review proceedings. That's not testimony or evidence taken as part of the peer review proceedings. Because in the Smith case versus Cleveland Clinic, which we cited, just because something is discussed in a peer review proceeding, in and of itself doesn't preclude the discoverability of that if that information is available from what's called an original source. You can still, in other words, what it does is it prevents, let's say, a hospital from taking something that's bad, simply submitting it to a peer review committee, having it stamped peer review, and then being able to hide behind that privilege if that medical record, for example, is available from an original source. If the complaint in this case, or information pertaining to the complaint, arose from an original source, in this case it would be Dr. Borrow himself, separate and apart from the discussions and the proceedings of the peer review committee, that's an original source and that would still be discoverable even if they were able to show a peer review committee.
Okay, so you're saying that's before peer review?
Prior to.
That's what I'm saying.
Yes.
So number two then, the nature of the complaint. Maybe the same thing.
Same analysis.
Okay, number three, the identification of the specific case on which a complaint against Dr. Borrow arose.
Same analysis. Exactly.
So what you're really saying is that you're not even into peer review yet.
We're not, because that was a burden that the plaintiffs did.
I understand that, but I'm just looking at it from the standpoint of, I don't mean to be short with you.
No.
I'm just looking at it from the standpoint of a number of things that affects the procedure here.
Yes, I think you summarized my argument correctly. It's the analysis that plaintiffs are making the logical leap to is because they're presuming that there was a peer review committee and evidence of same, which our position is that there wasn't. I would say that the orders that have been attached to the plaintiff appellant's briefs are all, many of them are motion eliminating issues where there wasn't this step through discovery, where there wasn't a chance to do this analysis under a Civil Rule 26 analysis, as opposed to the 401, 403 arguments, which, again, this court may ultimately end up coming to the same conclusion on a 401 or 403 argument, but until some discovery on that issue is had, we're really not in a position to say whether it's relevant or not. And the trial court will still be in a position to safeguard against that information if it's ultimately never deemed relevant. But at this point, there's no way for a court to do that analysis.
Or it could say, just like what you're saying is, that information could be turned over, and then it could be demonstrated as part of peer review, and you still can't.
It could. I mean, there's a lot of moving parts because we need to know more substance about whether a peer review committee met or whether it did. Obviously, if it turns out that Dr. Borrow, was testifying to something in case A saying it was black and in case B saying it was white, well, I think that would certainly go to his credibility or his qualifications as an expert. It's absolutely relevant. But again, that's an analysis that can only be made once Dr. Borrow is compelled to testify and answer, was a complaint filed against you? Was this why you resigned? I understand he resigned in good standing, but did he resign in good standing because the threat of sanction was pending over him and he was aware of it? That's what we're trying to get to in this case. I think that pretty much summarizes our position. Does the bench have any further questions? Thank you. We ask that the court affirm Judge Burge's ruling and consent the order. Thank you very much.
So you have 20 seconds.
Well, it's a circular argument, Your Honor, and it's been interesting to me as to why the defense firm wants to do this. If you take Judge Burge's order and flip it around to say the plaintiff is entitled to each one of these answers from a defendant, I'm certain that their position would be vastly different. This ACOG is a healthcare entity under the statute. There's no burden or no requirement under the Able decision or the Hammond decision from this court that there has.
Regretfully, I need to inform you that it's the end of your allotted time for today. Thank you
Thank
very
you.
much. Thank you both for your presentations this morning. The court will take the matter under advisement, issue a written decision, which will be known to all sides, as well as listed on our website and the House Supreme Court website. Thank you.
Thank you.